Imagine for a second, just imagine you are waking up tomorrow morning
Okay.
and you have a life-saving medical appointment.
Right.
Maybe it's, I don't know, your scheduled dialysis or a really highly specialized chemotherapy session.
Yeah, something absolutely critical.
Exactly.
Yeah.
Or even a post-op checkup that your surgeon was, like, incredibly insistent on.
Right, something you cannot miss.
But here is the catch, and it's a massive one. You don't have a car.
Oh, wow. Yeah.
You don't have a driver's license. And because of your specific, highly vulnerable medical condition, you physically cannot walk 3 blocks to a bus stop.
Right. You just can't do it.
You can't wait in the freezing rain or, navigate the steep, unforgiving stairs of a public transit system.
It's impossible.
So you are just sitting in your living room.
Yeah.
And you have to ask yourself, how do I actually get to the clinic?
It's an incredibly terrifying scenario.
It really is. But it is the daily reality for millions of people across the country.
Yeah, absolutely. Millions.
So enter the hidden, highly regulated, and honestly absolutely vital world of non-emergency medical transportation, or what the industry calls NEMT.
It really is a lifeline. And I mean, I do not use that word lightly.
No, of course not.
We are talking about the literal structural bridge between a patient and the healthcare they desperately need to survive.
Right.
Because without this logistical bridge, the best doctors, the most cutting-edge facilities, the most advanced treatments in the entire world,
They don't mean anything.
they are completely useless. They are useless because the patient simply cannot physically reach the point of care. NEMT is essentially the circulatory system of modern healthcare access.
That is exactly right. And whether you are a patient currently relying on these very services to survive, or maybe you're a caregiver agonizing over how to arrange transport for an aging loved one.
Which is so common.
It is. Or if you are just someone fascinated by how massive, complex, multi-billion-dollar healthcare logistics actually operate behind the scenes.
Oh, yeah, it's a huge machine.
Understanding your rights as a passenger in a medical vehicle is just a crucial piece of modern healthcare literacy.
Absolutely.
So today, that is our mission. We are taking a deep dive into the exact rights of an NEMT passenger.
We are going to decode the entire system for you.
And we have an incredibly comprehensive stack of source material on the table to guide us through this complex web today.
We really do. Rather than just relying on, generic advice, we are pulling directly from federal Medicaid fact sheets.
Right, the actual document.
Yeah, we are looking at the Medicaid and CHIP Payment and Access Commission, which is, the specific federal body mandated to report directly to Congress on these matters.
Specifically their Chapter 5 report.
Exactly, the Chapter 5 report. We also have the ADA National Network Guidelines.
Nice.
And we pulled state-specific transportation broker manuals from places like Oregon, Missouri, Georgia, and North Carolina.
So we've got a really broad view.
Yeah, and even highly technical HIPAA compliance guides tailored specifically for the medical transport industry.
But don't worry, we aren't going to just read you a bibliography.
No, that would be terrible.
Our goal is to take all of that dense, bureaucratic regulatory language and basically translate it into practical knowledge for you.
Yes, actionable stuff.
We are going to explore what a passenger is legally entitled to, where and how you can actually file a complaint with teeth if things go wrong.
The stuff that actually gets results.
Yeah, exactly.
Yeah.
The hidden operational rules most people never even think about, and exactly what questions you need to ask to stay in the know.
It's going to be a lot, but it's so important.
Okay, let's unpack this. Because before we can talk about how you complain when a ride goes off the rails, we need to understand why you have the right to demand that ride in the first place.
Right, the foundation of it all.
For the longest time, it felt like NEMT was treated by state governments as a sort of store coupon.
Oh, that's a good way to put it.
Like it was a nice administrative perk.
Yeah.
A little bonus if the state felt like having room in the budget for it.
Yeah, like a favor.
But looking at these recent sources, the whole legal foundation has shifted. It is no longer a store coupon. It is a legally binding gift card with a guaranteed balance.
That is a brilliant way to conceptualize the legal shift because, for decades, what the government called the assurance of transportation was largely just a regulatory interpretation.
Okay, meaning what exactly?
Meaning it was pushed by the Centers for Medicare and Medicaid Services to help beneficiaries access medically necessary services.
But it wasn't a hard law.
Exactly. Because it was just an interpretation, states often tried to tinker with it. Or they would seek waivers to avoid paying for it entirely.
Wow, just trying to get out of it.
Right, treating it like an optional administrative burden.
Hmm.
But a profound legal shift occurred quite recently.
Tell me about that.
The Consolidated Appropriations Act of 2021 formally codified NEMT as a mandatory statutory benefit under the Social Security Act.
Okay, so that changes everything.
I cannot overstate how important that is. It is no longer just a regulatory suggestion or like an administrative convenience that a state can easily brush aside.
It's federal law.
Exactly. You are statutorily entitled to this care.
That is a massive distinction. It elevates the passenger from someone receiving a charitable favor from the state to a citizen holding a federally protected entitlement.
100%.
And just to put the sheer scale of this into perspective, we aren't talking about a few thousand van rides a year.
Oh, not even close.
When you look at the MacPac report to Congress, what are we actually dealing with here?
The numbers are absolutely staggering, and this is exactly why Congress had to step in and regulate it so heavily.
No, it on me.
In fiscal year 2018 alone, there were over 60 million NEMT ride days.
60 million.
Yeah. And that translates to state and federal spending of roughly $2.6 billion.
$2.6 billion just on getting people to the doctor.
Yeah, exactly. And what's fascinating here is the demographic breakdown, because less than 5% of all Medicaid beneficiaries actually used NEMT that year.
Wait, really? Only 5%?
Yeah, it's a tiny fraction. But for that tiny fraction of people who do use it, it is the only thread keeping them connected to the healthcare system.
Who is mostly using it then?
The most frequent users are those eligible on the basis of profound disability or advanced age.
Okay, that makes sense.
Specifically, we see massive utilization by patients with end-stage renal disease who need dialysis 3 times a week.
Right, you can't miss dialysis.
Exactly. And also individuals with intellectual or developmental disabilities and patients managing severe behavioral health conditions.
So we have this massive multi-billion-dollar logistical machine. And it is governed by a standard that I found incredibly interesting in our
A
research.
core standard, yeah.
Right. It's called the least costly, most appropriate standard.
That's the magic phrase.
But hold on, let me push back on this a little bit.
Sure.
If I am looking at a state budget and I see $2.6 billion being spent and the mandate says least costly, doesn't that just mean the state transportation broker is going to hand you a public bus pass and wish you luck?
I mean, that is the fear.
Even if you are incredibly sick and vulnerable. Because if the ultimate goal is saving money, a $2 transit token is vastly cheaper than deploying a private medical van with a trained driver.
Obviously.
So how is that not just a massive loophole for states to abandon sick patients on a sidewalk?
It is a very valid concern. And honestly, historically, that tension between cost and care is exactly where abuses happen.
Right. States trying to cut corners.
But that is exactly why the second half of that phrase, the most appropriate part, is the passenger's absolute impenetrable shield.
Oh, so...
The most appropriate clause dictates that the state or the transportation broker cannot legally force you into a mode of transport that would jeopardize your health simply to save a few dollars.
So the medical need overrides the budget.
Exactly. The medical reality of the patient trumps the financial desire of the broker.
So how does that actually play out in real life? Like, what does most appropriate look like for someone who is genuinely struggling?
Well, let's say a patient is experiencing a high-risk pregnancy and they are in their 3rd trimester.
Okay.
Or perhaps they are a post-transplant patient on immunosuppressants.
Oh, meaning putting them on a crowded public bus during flu season could literally be fatal.
Exactly. It's a massive risk. Or maybe they have a cognitive limitation, like early onset dementia. That makes navigating a public bus schedule and a transfer system completely dangerous.
Right. They could easily get lost.
In all of those scenarios, they are explicitly exempt from public transit. The system is legally designed to adapt to the physical and cognitive reality of the patient.
That makes a lot of sense. So if they can't take the bus, what is the next step up?
They have a right to a higher level of service. For many, that means a private sedan or a taxi. But it goes much further than that. If a patient uses a wheelchair and they cannot self-transfer, meaning they cannot stand up, fold their wheelchair, put it in the trunk, and slide into a standard car seat.
Which a lot of people can't do.
Right. If they can't do that, they have a right to a wheelchair-accessible van.
Got it.
This van must be equipped with a mechanical lift or a ramp. Or, in extreme cases, if a patient needs to remain completely supine due to a spinal issue or severe weakness, they have a right to a specialized stretcher van.
But surely the broker doesn't just take the passenger's word for it, right?
Oh, no, definitely
I
not.
imagine you can't just call up and say, yeah, I'd prefer the private sedan today, please.
Correct. This determination isn't arbitrary at all, and it isn't based on patient preference.
How was it decided then?
It is formally documented by the patient's doctor through what is called a physician certification statement or a medical necessity form.
Okay, so there is paperwork.
Lots of it. The doctor essentially writes a prescription for the specific type of vehicle. This form clearly outlines to the broker exactly what the patient physically requires to survive the journey.
And once that's signed,
Once the doctor signs that form, the most appropriate vehicle becomes a mandated requirement for the broker to fulfill. They can't argue with it.
okay, so the Medicaid statute, reinforced by the Social Security Act, guarantees that you get the ride. And the doctor's paperwork dictates the medical appropriateness of the vehicle.
You've got it.
But once you are actually standing at the curb, waiting to board, a whole new set of federal protections kicks in.
This is where it gets really detailed.
Right. If the Medicaid system guarantees the ride itself, the Americans with Disabilities Act, the ADA, guarantees how you are treated during that ride.
Yeah.
And it governs the literal physical safety of the vehicle.
Precisely. If we connect this to the bigger picture, the ADA provides the overarching civil rights framework that governs the operational standards of the entire ground transportation industry.
Including NEMT.
Including NEMT, yes. When we dive into the sources, we are looking primarily at Title II, which applies to public transportation entities, and Title III, which applies to private transportation entities.
And there was a core concept here that stood out, equivalent service.
Yes, equivalent service is non-negotiable.
Let's focus on that term, because I think a lot of people have experienced the absolute nightmare of calling a cab company, telling them you have a wheelchair, and suddenly the wait time jumps from 10 minutes to 4 hours.
A very common, very illegal practice.
So equivalent service means a private NEMT provider, or even a third-party taxi company contracted by the state broker,
Yeah.
cannot just say, hey, sorry, we don't have a ramp vehicle available today, so you'll have to wait until tomorrow, or you have to pay a premium for a specialty service.
Right, exactly. They are legally prohibited from doing that. If a private provider uses vehicles that are not inherently accessible, like a fleet of standard sedans, they must provide equivalent service in the most integrated setting appropriate.
What does that mean in practice?
That means an individual with a disability must receive service in the exact same time frame, covering the exact same geographic area, and at the exact same cost as a passenger without a disability.
No exceptions.
No exceptions. There are absolute prohibitions under the ADA against charging disabled passengers higher fares. They also cannot charge extra fees or, baggage rates for stowing mobility equipment.
Like folding a walker or storing a collapsed wheelchair in the trunk.
Right. The cost of accessibility is borne by the provider, not the passenger.
I think this is where people who don't use these services really miss the complexity of it.
They definitely do.
They just assume an NEMT vehicle is just a modified minivan with the back seats taken out.
Yeah, just an empty van.
But when you actually read the ADA National Network guidelines,
Okay.
you realize it isn't just a car. It is a highly engineered accessibility pod.
It really is an engineering marvel.
The physical rights guaranteed to a passenger under the ADA are incredibly specific and mechanically rigorous.
They absolutely are. Let's look at the mechanical lifts on these vans, for example. The ADA guidelines dictate that a vehicle's mechanical lift must have a minimum design load capacity of 600 pounds.
Wait, 600 pounds?
Yes, 600.
That sounds massive.
Yeah.
Why does a wheelchair lift need to hold the weight of a small motorcycle?
It's a great question, and it really comes down to the evolution of mobility technology. We aren't just talking about lightweight manual hospital chairs anymore.
Right, the technology has advanced.
Exactly. Modern complex rehab technology, which are the highly customized, motorized power chairs that many patients require for severe conditions, like ALS or quadriplegia.
Those look really heavy.
They are. Those chairs alone, with their heavy batteries, tilt and space mechanisms, and custom seating, can weigh 350 to 400 pounds completely empty.
Oh, wow. I hadn't even considered the battery weight.
Yeah, the batteries are incredibly dense. Add a 200-pound adult patient sitting in that chair, and you are immediately pushing 600 pounds.
That is wild.
If a transportation company uses an older, non-compliant lift rated for only 400 pounds, the hydraulic system could literally fail mid-air, dropping the patient onto the pavement.
Oh my God, that would be catastrophic.
It would be. So the 600-pound minimum is a critical safety threshold. Furthermore, the lift platforms themselves have to accommodate a wheelchair measuring at least 30 inches wide by 48 inches long.
They literally measure the inches.
Yes. Even the doors and the passenger steps are strictly regulated. Stepwells must be illuminated so visually impaired passengers don't trip in the dark, and they must have slip-resistant surfaces.
And what happens when this highly engineered equipment breaks? Because, mechanical things fail all the time.
They do, constantly.
If a vehicle's lift breaks down on a Tuesday, can the company just shrug, cancel the patient's dialysis trip, and say, hey, sorry, the van is in the shop?
Absolutely not. The ADA requires that the accessibility feature must be promptly repaired.
Okay, but what about the patient that day?
That is the more important part. In the interim downtime, the transportation company must provide an alternative accessible option.
How do they do that?
They have to subcontract the ride to another provider or send a different accessible vehicle from their own fleet. The passenger's right to travel cannot be interrupted just because a hydraulic hose sprang a leak.
That physical shield is just so crucial. And speaking of physical shields, there is another major ADA protection that often causes friction between drivers and passengers.
Oh, service animals.
Yes, service animals.
The ADA guarantees the absolute right to travel with a service animal. The Department of Transportation regulations explicitly define a service animal as any guide dog, signal dog, or other animal individually trained to provide assistance to an individual with a disability.
Right, and here's the kicker that many drivers fail to understand.
Yes, this applies regardless of whether the animal has been licensed or certified by a state or local government.
Meaning, as a passenger, you do not have to present some laminated certification card to the driver to prove your dog is allowed on board.
Correct. In fact, mandatory certification doesn't legally exist under the ADA.
Really? I feel like people always ask for papers.
They do, but it's illegal. If the dog is trained to perform a specific task, like alerting to a seizure or guiding a visually impaired person, the driver must allow the animal in the vehicle.
No questions asked.
Pretty much. They cannot deny the ride, and they absolutely cannot charge a cleaning fee just because the animal is present.
So we have covered the physical safety of the passenger and the mechanical requirements of the van. But as I was reading through these state broker manuals and compliance guides, another realization hit me.
What was that?
It's something most people never consider. We are talking about physical safety, but what about digital safety?
Ah, yes. The data side.
Exactly. A medical transport vehicle, especially when you are doing a shared ride with 2 or 3 other patients in the back of the van, is essentially a rolling extension of a doctor's waiting room.
It absolutely is.
The driver knows your full name, they know your home address, your phone number, and exactly what clinic you are going to.
It is a massive vulnerability. In fact, it is one of the most overlooked aspects of medical privacy, which is why HIPAA, the Health Insurance Portability and Accountability Act, applies just as strictly in the front seat of that transport van as it does at the nurse's station in a hospital.
So the van companies have to follow a HIPAA.
Yes. NEMT providers, from the massive state brokers down to the local mom-and-pop van companies, are legally classified as business associates under HIPAA.
What does that mean legally?
This means they are fully bound by the privacy rule, the security rule, and the breach notification rule.
Let me stop you there and pose a visceral, practical hypothetical.
Okay, let's hear it.
Let's say a driver is halfway through their shift. They pull over at a diner to grab a cup of coffee. They leave their dispatch tablet sitting on the counter, screen illuminated, and it has the entire day's passenger manifest right there on it.
A terrible scenario.
Is that treated with the same legal severity as a hospital administrator leaving a stack of physical medical records on a park bench?
Absolutely. Under federal law, it is treated exactly the same. It is a severe breach of protected health information, or PHI.
But wait, a skeptic might say, it's just a list of names and addresses. It's not like the tablet has their blood test results or their MRI scans on it. Why is it a severe breach?
Because in the context of NEMT, the simple destination of a trip is considered protected health information.
Oh, the destination itself.
Yes. If someone looks at that tablet on the diner counter and sees that John Doe from 123 Main Street is being dropped off at an oncology clinic, or a specialized behavioral health center, or a methadone clinic for substance use disorder.
Oh, wow. Yeah, that reveals a lot.
That destination alone reveals the patient's highly sensitive medical condition. If that information gets out, it could impact the patient's employment, their social standing, or their personal safety.
That is terrifying.
Therefore, drivers are strictly trained and legally required to protect that data. They cannot discuss identifying information with anyone not directly involved in the patient's care.
So they can't just chat about their day with another passenger.
No. And if there are multiple patients in the van, the driver cannot leave the daily schedule visible on the dashboard.
And if that tablet is left at the diner, or if a hacker gets into the local van company's unencrypted scheduling software, what rights does the passenger have?
Under the Asiapura breach notification rule, the passenger has an absolute right to be notified that their data was compromised.
They can't just hide it.
No, they cannot legally sweep it under the rug. Furthermore, passengers have the right to request and receive a full, itemized copy of their own transportation records from the broker or the provider.
So you can check your own history.
Yes. They have a right to see exactly who accessed their data and when. The digital footprint of an NEMT trip is heavily guarded, and providers are required to use HIPAA-compliant encrypted scheduling software and conduct regular security audits to maintain their state contracts.
Okay, let's take a breath and summarize where we are.
We've covered a lot of ground.
We have. We have the statutory federal right to the ride itself. We have the physical ADA protections ensuring the vehicle won't drop you, and the digital pay shield ensuring your privacy is locked down.
The 3 pillars.
But honestly, none of that matters. Not the heavy-duty lift, not the encrypted tablet, if the ride doesn't actually show up at your house.
Yeah, if the van never arrives, none of it helps.
Exactly. Let's look at the operational rights passengers hold. We are talking about the daily entitlements regarding time, companions, and reliability.
The day-to-day realities.
Right. And here's where it gets really interesting. Because while the administrative policies vary slightly state by state, the core clinical necessity remains exactly the same.
Right. And let's start with a crucial operational right, the right to accompaniment.
Meaning bringing someone with you.
Yes. The NEMT framework recognizes a fundamental truth about healthcare. Many patients simply cannot travel alone safely.
Which makes perfect sense.
If a passenger is a minor child, or if an adult passenger has a cognitive or physical condition, like severe dementia, or they are prone to seizures, or they just need physical help navigating the massive hallways of the hospital once they are dropped off.
Getting dropped at the curb isn't enough for them.
Exactly. They have the right to bring a medical escort. This escort could be a parent, a legal guardian, a hired nurse, or just a family caregiver.
And do they have to pay for an extra seat?
No, and this detail is vital. The broker must allow this escort to ride in the van without charging any additional fee to the Medicaid member or the escort.
I noticed an interesting nuance in the Georgia Medicaid NEMT guidelines regarding this.
Oh, what was that?
They explicitly state that a medical escort must generally be 18 years or older to take responsibility for the patient, but they also have a very human provision.
I love when policy actually reflects reality.
Right. If an adult Medicaid member has a minor child, and they have absolutely no child care available, the broker might allow the minor child to ride along to the appointment if there's an available seat in the vehicle.
That is fantastic.
It's about practical, real-world access to care. If the mother can't bring her toddler, she misses her chemo. So the system has to adapt.
It has to, yeah.
But the biggest operational right, the one that generates the absolute most anxiety and the most formal complaints, is time. We're talking about on-time performance, or OTP.
This is where logistics collides directly with clinical risk.
How so?
Well, in the NEMT world, a vehicle being late isn't just an annoyance like a delayed pizza delivery. It is a severe clinical danger.
Because of the appointments they're going to.
Exactly. Let's go back to our end-stage renal disease patient. If that patient misses their specific time window for dialysis, they don't just get to walk in an hour later.
Right. The clinic's chairs are fully booked.
Yes. If they miss that session, the deadly toxins in their blood continue to build up. Missing a ride can literally trigger a life-threatening cardiac event.
So punctuality is literally life or death.
Therefore, state Medicaid agencies and the transportation brokers establish incredibly strict OTP standards in their contracts. The general industry-wide threshold for being late is 15 minutes.
Wait, hold on. 15 minutes?
Yep, 15 minutes.
In a major metropolitan area with gridlocked traffic, construction zones, and totally unpredictable weather, how is a 15-minute window practically enforced?
It sounds impossible, I know.
Does the dispatcher actually hit a panic button at minute 16, or is that just a nice idea written on a piece of paper in an office somewhere?
Oh, it is fiercely enforced, primarily through financial penalties. If a transportation provider's fleet consistently misses that 15-minute window, the state broker will start fining them heavily.
Get them in the wallet.
Exactly. Or eventually strip them of their Medicaid credentialing entirely. If your pickup window is 9 a.m. and the clock strikes 9:16 a.m., your rights as a passenger have officially been violated.
Wow, okay. And what can the passenger do at 9:16?
At that exact moment, the passenger has a right to immediate intervention. They should immediately call the broker's dedicated "Where's my ride" line.
The broker tracks this.
Brokers are contractually obligated to track these late pickups in real time. If the original van is stuck in traffic, the broker must immediately dispatch a secondary rescue vehicle from another company to ensure the patient doesn't miss their clinical window.
And what's great is that in 2026, passengers shouldn't just be sitting in their living room in the dark, staring out the front window, wondering if a car is ever coming.
No, the technology has evolved.
Right. Modern NEMT has finally caught up with the rest of the logistical world. They utilize advanced GPS tracking and automated trip updates.
It's game-changing.
According to the industry resources we reviewed, automated notifications via SMS text, email, or automated voice calls are becoming the absolute standard. Passengers have the right to real-time information.
Yes, transparency is key.
You have the right to receive a notification the day before confirming your trip. And you have the right to real-time, Uber-style updates on your driver's exact location.
What's fascinating here is how this specific application of technology is fundamentally shifting the power dynamic back to the passenger.
Giving them some control back.
Exactly. In the old days, you were at the mercy of the dispatcher. You just had to wait and hope. Now, automated systems reduce no-shows and give the incredibly anxious patient peace of mind. They can see the van is 3 blocks away.
That has to lower everyone's blood pressure.
Oh, dramatically. But this leads us to another hidden layer of the NEMT world, one that passengers interact with intimately, the driver and the vehicle itself.
Right. Who exactly is behind the wheel? Passengers have incredibly strict rights regarding who is legally allowed to transport them.
They do.
I think most people assume that an NEMT company operates just like a rideshare app, where anyone with a 4-door sedan and a somewhat clean driving record can just download an app, sign up, and start driving sick people around.
Yeah, that is a huge misconception.
But the regulatory reality is so much more rigorous than that.
It is vastly different from a standard rideshare. You cannot just moonlight as a medical driver on your weekend off.
There are barriers to entry.
High barriers. Drivers must undergo extensive, multi-layered credentialing before they ever turn the ignition. First, they have to pass deep criminal background checks.
And this isn't just looking for speeding tickets, right?
No, this includes screening the driver against the Federal Office of Inspector General's exclusion list.
Okay, what is the OIG exclusion list?
It is a federal database of individuals who have been convicted of crimes related to healthcare fraud, patient abuse, or financial exploitation.
Oh, wow.
Yeah. The state has to ensure the driver hasn't previously scammed the Medicare system before they are allowed alone in a van with a vulnerable senior.
That is a very smart check.
Furthermore, they must pass stringent randomized drug and alcohol tests. And crucially, they must complete specialized hands-on training.
Like what kind of training?
The most common industry standard is the Passenger Assistance, Safety and Sensitivity Certification, or the PASS program.
And that training essentially dictates the rules of engagement between the driver and the passenger. It's a highly choreographed interaction.
It really is.
For instance, when looking at the Virginia Medicaid manual, it clearly states that all drivers must wear a company uniform shirt and display an official NEMT program ID badge in a highly visible, conspicuous location.
They can't just show up in sweatpants.
Right. The driver must physically present this ID badge to the member at their front door or to the facility nurse upon arrival. You have the right to know exactly who is taking custody of your transport.
And the rules regarding physical contact are heavily, heavily regulated.
To protect both parties, I assume.
Yes, to protect both the patient from abuse and the driver from false accusations. Drivers are specifically authorized and trained to physically help a passenger step into the vehicle, assist them into a seat, and secure their seatbelt.
But that's it.
Well, if the passenger is in a wheelchair, the driver is trained to use what we mentioned earlier, the 4-point securement system.
Let's actually talk about that securement system, because it's
Okay.
not just a matter of locking the brakes on the wheelchair, right?
No, absolutely not. Locking the brakes does nothing in a car crash.
Right, because of the momentum.
Exactly. A standard wheelchair is designed to roll. It is not designed to be a static car seat. In an accident at 30 miles per hour, a 200-pound chair becomes a deadly flying projectile.
That is terrifying to picture.
It is. So the four-point securement system, known technically as the WC-18 or WC-19 standard, isn't just a couple of bungee cords.
What is it then?
It is a heavily engineered restraint mechanism. The driver must physically kneel down and use heavy-duty retractors to structurally anchor the solid metal frame of the wheelchair directly into the steel floor chassis of the van.
So it's bolted to the actual frame of the car.
Yes. This transfers the kinetic energy of a crash away from the fragile wheels and into the frame of the vehicle.
That sounds like it takes a lot of effort.
It takes time, it takes physical effort, and the driver must be perfectly trained so they don't accidentally hook the restraint to a removable footrest.
Oh, because that would just snap right off in a collision.
Instantly, it would provide no safety at all.
That is an incredible amount of mechanical responsibility placed on the driver. But beyond that specific safety-related contact, the physical boundaries are absolute.
Correct. The guidelines are explicit. Any other touching, lifting a patient out of bed, carrying them down a flight of stairs, or inappropriate physical familiarity is entirely strictly prohibited and should be reported to the state broker immediately.
So they're not nurses.
Exactly. NEMT drivers are transporters, not EMTs and not home health aides.
That is a critical boundary.
Yeah.
Here's another firm, non-negotiable boundary I found in the manuals. Drivers are absolutely forbidden from soliciting money, goods, or tips from passengers.
That is a huge one.
This is a fully government-funded medical service. The passengers should never, ever feel pressured to open their wallet or tip the driver to ensure they get picked up on time tomorrow.
Absolutely. And just as the driver is heavily vetted, the physical vehicle undergoes intense granular scrutiny as well.
Tell me about the vehicle checks.
Let's look at the Missouri Department of Social Services guidelines as a prime example of state oversight. They require an initial, exhaustive 45-point vehicle inspection by a state field monitor before a newly purchased vehicle can transport a single Medicaid participant.
45 points. What are they actually checking on a list that long?
They check everything. They verify the expiration dates on the onboard fire extinguisher and the bodily fluid first aid kit.
Wow, they look at the expiration dates.
Yes. They check the calibration of the GPS systems, they measure the tread depth on the tires, they test the climate control system.
Oh, because temperature is a medical issue.
Because a broken AC in August is a medical emergency for a respiratory patient. And of course, they test the mechanical integrity and weight-bearing capacity of those wheelchair lifts we discussed earlier.
And is this just when they buy the van?
No, this isn't a one-time check. These vehicles are then re-inspected every 6 months.
Okay, but as a passenger, when a white van pulls up to my house, how do I know it has actually passed that test? How do I know I'm not getting into a rogue, uninspected vehicle?
In many states, including Missouri, the state uses a visual verification system. Once a vehicle passes that rigorous 45-point inspection, the field monitor applies a highly specific, camper-proof NEMT broker decal to the window.
Okay, so you can actually see it.
Yes. This decal usually has an expiration date on it. This is a visual cue, a literal stamp of approval that passengers should actively look for before boarding to ensure the vehicle is compliant, insured, and safe.
So we built this picture of a perfectly regulated, highly engineered, flawlessly executed system. But let's live in the real world for a second.
The real world is messy.
Exactly. With 60 million ride days a year, things are going to fall through the cracks. The system is going to fail.
It's inevitable.
A driver's going to be late. A vehicle's going to show up smelling like cigarette smoke. Or, worst of all, the state broker outright refuses to authorize your trip to the cardiologist.
Which happens more often than people think.
So how does a passenger actually fight back? This is where we get into Section 6, taking action. And I want to frame this carefully.
Okay.
If a driver is incredibly rude to you on the phone, is that the exact same complaint process as the state refusing to send a wheelchair van for your paralyzed grandfather?
This raises an important question, and it is the crux of patient advocacy. The answer is absolutely no.
They are completely different.
Completely different. There is a vital legal distinction between being annoyed by a service failure and being legally wronged by an administrative decision.
Okay, unpack that.
This is the difference between filing a grievance and filing an appeal. Understanding this difference is the most powerful tool a passenger has.
Okay, let's break that down piece by piece. What exactly is a grievance?
A grievance is a formal complaint about the quality of the service provided. You are not arguing about whether you are allowed to have a ride. You are complaining about how that ride was executed.
Give me some examples.
If your driver is driving recklessly, speeding, or texting while driving, if the vehicle is filthy, if the air conditioning is broken, or if the dispatcher on the phone was incredibly rude and unprofessional to you.
Those are all grievances.
Yes, those are grievances.
Yeah.
You are reporting that the delivery of your mandated benefit was substandard, dangerous, or undignified.
And how do you file a grievance that actually gets results?
You start directly with the transportation broker that manages your region. Every single state broker, whether it's a massive company like MTM, MotiveCare, or Verida, has a dedicated grievance or We Care phone line.
Do they actually listen to those, though?
And here is the important part. They don't just take a message and throw it in the trash. They are contractually mandated by the state to log every single complaint, open a formal investigation, and take corrective action against the local transportation provider if the complaint is substantiated.
What kind of action?
They can fine the provider, mandate retraining for the driver, or pull the vehicle off the road entirely.
I found a fascinating, lesser-known right buried deep in the Missouri and Oregon member manuals regarding grievances. It is something called the Do Not Ride request.
Yes, that is a fantastic piece of leverage for the passenger.
Right. If you have a genuinely bad, terrifying, or unsafe experience with a specific driver or a specific local transportation company, you don't just have to complain and cross your fingers hoping you don't get them again next week.
You have an actual option.
You can formally request a Do Not Ride order. You ask the broker to exclude that specific driver or that entire company from your future trips.
And the broker has to respect that.
The broker investigates, and in many cases, they will digitally flag your member file so the scheduling software physically cannot dispatch that dangerous company to your home ever again. You have the power to curate your own safety.
That is a powerful tool for patient autonomy. Now, let's contrast a grievance with an appeal. If a grievance is about quality, an appeal is about a legal decision regarding your underlying benefits.
So this is the big stuff.
This is where the stakes are highest. Let's say your doctor requests a ride for you to go to an out-of-network specialist, and the broker denies the trip entirely, claiming it's not a covered service.
Oh, right.
Or, let's say your doctor fills out the medical necessity form requesting a wheelchair van because you are far too weak to sit upright in a car. But the broker's algorithm downgrades you, denies the van, and mails you a public bus pass instead to save money.
Wow, that's terrible.
That is an adverse legal action against your statutory rights, and it instantly triggers your constitutional right to due process.
Because, as we established way back in the beginning, this isn't a store coupon. This is a statutory, federally protected entitlement. They cannot just take it away or downgrade it without a legal fight.
Exactly. When a service is denied, suspended, or downgraded, the broker cannot just tell you no over the phone. They are legally required to send you a formal written document called a notice of action.
Is that the same as the NOABD?
Yes, sometimes referred to as a notice of adverse benefit determination, or NOABD. This letter is critical. It must explain exactly why the decision was made, what specific medical evidence or state rule was used to justify the denial, and most importantly, it must clearly explain your right to appeal the decision.
Think of the appeal process like the VAR, the video assistant referee in professional soccer.
I like that analogy.
The broker is the referee on the field.
Mm-hmm.
They blew the whistle and made a call to deny your ride. But you have the right to demand they go to the monitors.
You can challenge the play.
You can demand that an independent judge reviews the exact tape, the doctor's paperwork, the medical necessity form to see if the broker blew the whistle too early or misinterpreted the rules. But time is of the essence here, right?
It absolutely is. Passengers generally have a strict 90-day window from the date printed on that NOABD letter to request what is called a state fair hearing.
What happens at a state fair hearing?
This is an actual administrative court process. It is not managed by the broker. It is managed by an independent state administrative law judge.
So it's totally neutral.
Yes. During this hearing, you have the right to present new evidence, have your doctor submit written testimony explaining why you need the specific transport, and you even have the right to have an attorney, a social worker, or a legal aid advocate represent you.
It is a true legal check against the broker's power.
Exactly.
So, to summarize the internal system, you file a grievance for quality issues like a bad driver, and you file an appeal for denied or downgraded benefits. But what if the issue is bigger than a rude driver or a denied trip?
You mean something structural?
Yeah. What if we are looking at systemic discrimination, civil rights violations, or outright intentional financial fraud?
That requires escalating the issue completely outside of the state Medicaid system and bringing in the heavy hitters.
Who do you call?
Well, if a private transportation provider commits a severe ADA violation, for example, if a taxi company contracted by the broker pulls up, sees you have a seizure alert service dog, and the driver outright refuses to let you in the car, leaving you stranded.
That is awful.
That is a civil rights violation. You bypass the broker entirely and file a formal civil rights complaint directly with the U.S. Department of Justice, Office of Civil Rights, or you can call the federal ADA information line at 1-800-514-0301.
And what about fraud? Because CMS has a massive dedicated fact sheet just on NEMT fraud. And fraud isn't a victimless crime.
It definitely isn't.
Every dollar a corrupt company steals is a dollar drained from the $2.6 billion pool that is supposed to help sick people. What does NEMT fraud actually look like on the ground?
Fraud in this industry can be incredibly brazen. If you witness fraud or abuse, for example, if a driver picks you up and offers to take you to a grocery store, a casino, or a friend's house, and then bills Medicaid claiming it was a medical trip.
Oh, wow. People do that.
Yes, that is a ghost ride, and it is highly illegal. Or if you notice a driver intentionally taking a massive hour-long detour away from the clinic just to rack up extra mileage to overbill the state.
The longer the trip, the more they get paid.
Exactly. Or upcoding, where a provider transports you in a highly expensive stretcher van and bills the state for it when you are perfectly capable of walking into a standard sedan.
They're just gaming the system.
All of that needs to be reported immediately. You can report that directly to the federal HHS Office of Inspector General hotline, which is 1-800-HHS-TIPS, or you can report it directly to your specific state Medicaid fraud control unit. They take these tips incredibly seriously.
So we have covered the massive scope of the law, the mechanical physics of the vans, the digital privacy of the tablets, and the legal battleground of grievances and appeals.
You really went deep.
What does this all mean for you, the listener? How can a passenger or a caregiver proactively protect themselves and stay in the know before a crisis happens?
Knowledge really is your best, most potent defense. First, the moment you are approved for Medicaid or NEMT services, demand and thoroughly read the member brochure or rider's guide issued by your region's broker.
Don't just throw it away.
Right. These aren't just glossy marketing pamphlets to throw in the recycling bin. They are essentially your contract. They outline your exact rights, your exact responsibilities, and the specific phone numbers for your region.
And second,
always have the broker's "Where's My Ride" phone number saved directly in your phone contacts or physically written down and kept in your wallet.
that is such a crucial point. Do not wait until you are stranded on a freezing sidewalk outside a dialysis clinic at 6 p.m. to try and frantically Google a 1-800 number on a dying cell phone. Have it ready.
Exactly. Prepare for the failure of the system. Third, when you book your ride with the dispatcher, be proactive. Ask them explicitly about their automated notification option.
The text alerts.
Request to be opted into SMS text updates so you can actively track your driver's GPS location. Take the power back. And finally, when that white vehicle pulls up to your curb, act like an inspector.
Check them out.
Verify the vehicle. Look for that state inspection decal on the window. Look at the tires. And ask to see the driver's official ID badge before you ever step foot inside the van. You have the absolute right to know exactly who is taking legal and physical responsibility for your medical transport.
This has been an incredibly eye-opening journey. I think we've successfully moved from seeing NEMT as just some background logistical chore, a boring line item on a state budget, to recognizing it for what it truly is, a highly regulated, technologically complex, patient-centric civil right.
It absolutely is. And this raises an important question, a question that the entire healthcare industry is going to have to grapple with in the near future.
Oh, is that?
As the U.S. population continues to age at a historic rate, and as chronic debilitating conditions like end-stage renal disease that require frequent, mandatory transport continue to increase, the demand for highly specialized, wheelchair-accessible NEMT is going to absolutely skyrocket.
It's just going to get bigger.
The physical and financial capacity of the system is going to be tested like never before. Will access to seamless, technologically advanced, and dignified medical transportation become the defining civil rights and health equity issue of the next decade? I firmly believe it will be.
It is a profound, heavy question, and one that federal policymakers, massive healthcare providers, and local transportation networks are going to have to answer very soon. Because as we have learned today in vivid detail, the statutory right to the best healthcare in the world means absolutely nothing if you don't have the logistical right to actually get through the clinic doors.
Well said.
As we wrap up this deep dive, it's crucial to partner with organizations that take these passenger rights seriously. SwiftAid Transport is dedicated to providing a level of transparency to make sure passengers will be informed of their rights and SwiftAid compliance. Visit us at www.swiftaidtransport.com. Thank you for joining us on this deep dive into the hidden world of medical logistics. We hope you feel empowered. Stay curious, stay well informed, and remember, the next time you see a medical transport van on the road, waiting at a stoplight, you'll know that it isn't just a vehicle. It is a highly engineered, legally protected lifeline. Catch you next time.